I'm Scott Hervey from Weintraub Tobin.
And I'm Josh Escovedo with Weintraub Tobin. The Ninth Circuit recently refused to revive a lawsuit filed by Evel Knievel's son, alleging that Disney infringed his company's intellectual property and publicity rights associated with Evel Knievel by creating the Canadian stuntman character Duke Caboom in Toy Story 4. That's what we'll be discussing on this installment of the briefing by the IP Law Blog. In October 2021, Evel Knievel's son, through his company K&K Promotions, Inc., filed suit against Disney, claiming that Disney's creation of the Toy Story 4 character Duke Caboom, a Canadian motorcycle stuntman, infringed the company's IP and its publicity rights associated with Evel Knievel. The district court dismissed the matter in response to a motion to dismiss, finding that the challenged product is an expressive work under Rogers versus Grimaldi, and that Duke Caboom clearly has artistic relevance and was not explicitly misleading. If this sounds familiar to you, it's because we discussed the motion to dismiss previously on the briefing.
But Knievel's son was obviously displeased with the ruling, so he appealed to the Ninth Circuit, hoping the appellate court would revive his case. Much to his chagrin, he learned that he does not have a friend in the Ninth Circuit.
I think that's a fair statement, Scott. The Ninth Circuit essentially echoed the district court and found that the Rogers test applied to the case, that Caboom did have artistic relevance, and that K&K did not allege sufficient facts to show that the character was explicitly misleading as to its source. The Ninth Circuit stated that the explicitly misleading test imposes a high bar that requires the use to be an explicit indication, overt claim, or explicit misstatement about the source of the work. In evaluating whether the use of a mark is explicitly misleading, the court considers the degree to which the junior user uses the mark in the same way as the senior user, and the extent to which the junior user has added his or her own expressive content to the work beyond the mark itself. The Ninth Circuit found that neither consideration was met by K&K in this instance.
For starters, the Ninth Circuit found that, unlike Evel Knievel, Duke Caboom is a fictional character in an animated film about toys that come to life. The Ninth Circuit also found that Disney added significant expressive content to the mark to make it different from Evel Knievel.
Right. For example, Disney created a character with a different name, appearance, and backstory from Evel Knievel. Disney never suggested that Evel Knievel was involved in Toy Story 4, and Evel Knievel was never even mentioned in the film. For these reasons, the Ninth Circuit found the dismissal under Rogers was appropriate.
The court also addressed the district court's dismissal of the right of publicity claim. Remember, this case was filed in district court in Nevada, so the court had to analyze Nevada's right of publicity laws and right of publicity defenses, including the transformative use defense, which is recognized in Nevada. The Ninth Circuit found that K&K did not challenge the applicability of the defense to such a claim under Nevada law. To determine if a use is transformative under Nevada law, courts will consider various factors that balance the defendant's First Amendment rights with the plaintiff's claimed right of publicity.
And the Ninth Circuit found that those factors favored Disney. The Ninth Circuit stated that Duke Caboom, the action figure, is more than a mere likeness or literal depiction of Evel Knievel. Even if the character may be generally reminiscent of Knievel to some extent, the district court properly concluded that it is not a literal depiction and instead shares general features basic to stuntmen. Moreover, the economic value of the toy action figure does not derive from Evel Knievel's persona. Instead, it reflects the success of Disney's Toy Story franchise and its popularity among children and adults, for some of us, but that's neither here nor there. So accordingly, the Ninth Circuit affirmed the dismissal of the right of publicity claim as well.
Josh, I'm a fan of Toy Story 2, so don't feel alone, as I'm sure lots of our listeners and viewers are as well. So I guess we can mark another win in the column for Disney and Woody and his gangs. Thanks for sharing, Josh.
Thanks, Scott.
Thanks for tuning in to this installment of the briefing by the IP Law Blog. If you like this episode, please remember to give us a thumbs up or give us a rating. It really helps. And be sure to check out our back episodes. And you can also visit us at theiplawblog.com.